Warm regards everybody. I am Macabangon Dadia, criminal law 2 student under attorney named na Dulay. This case refers to a bank robbery committed in band with multiple frustrated homicide and assault upon agents of person in authority. Under Article 296, robbery committed by a band. The element of which is number 1, when at least 4 armed malefactors take part in the commission of a robbery, it is deemed committed by a band. Number 2, if any arm used be unlicensed firearms, the penalty imposed upon all the malefactors shall be the maximum of the corresponding penalty provided by law, without prejudice to the criminal liability for a legal possession of such firearms. This is a special aggravating circumstance applicable only in a case of robbery in band. Any member of the band who was present at the commission of a robbery by the band shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. In robbery by a band, proof of conspiracy is not required. In the case of the people of the Philippines versus Crescencio Dobble, Simeon Dobble, and Antonio Romaquin, GR number L30028, May 31, 1982. The facts of this case is as follows. Late in the night of June 13, 1966, 10 men, almost all of them heavily armed with pistols, carbines, and Thompsons, left the shores of Manila in a motor banca and proceeded to Nabotas, Rizal. Their mission to rob the Nabotas branch of the Prudential Bank and Trust Company. Once in Nabotas and taking advantage of the darkness of the night, 8 men disembarked from the banca and proceeded to the beach in the direction of the branch bank. Within a few minutes, shots were heard, throwing the people around in panic. As confusion reigned, the people ran in different directions, scampering for safety. As time went on, the shots grew in intensity. As the commotion died down, the 8 men returned to their banca, still fully armed, and some of them carrying what looked like bayongs. They boarded the waiting motor banca and sped away. As a result of the shooting, many people got killed and some injured. Among those who were killed were agents of the law. Only 5 of 10 accused were brought to trial. The other 5 named only as John Does, in the information having remained at large. 2 of the 5 accused were acquitted. It is only Crescencio Dobble, Simeon Dobble, and Antonio Romaquin appealing in the charge of bank robbery committed in band. Issue: whether or not the 3 accused can be considered as accomplices of the crime of robbery in band. Held. As to appellant Simeon, the evidence shows only that the malefactors met in his house to discuss the plan to rob the Prudential Bank. This circumstance, standing alone, does not conclude his guilty beyond reasonable doubt. The only link between Simeon and the crime is his house having been used as the meeting place of the malefactors for their final conference before proceeding to Nabotas to rob the Prudential Bank thereat. Taking up next the case of appellants Antonio Romaquin and Crescencio Dobble, their main contention is that their extrajudicial statements upon which their conviction was principally made to rest are inadmissible for having been allegedly obtained by force and intimidation, and in violation of basic constitutional rights to counsel and against self-incrimination. In support of this contention, appellants have only their own self-serving testimony to rely upon. The apprehension of the malefactors that upon realizing the full impact of their vicious misdeeds, Romaquin might speed away from the scene in fear of being implicated, assumed by the measure they had taken to prevent his escape, is further proof that Romaquin was not considered a conspirator, who is one who should not be looked upon with mistrust. For this part, the circumstances pointed out would not make appellants liable as co-principals in the crime charge. At the most, their liability would be that of mere accomplices. An accomplice is one who, not being principal as defined in Article 17 of the Revised Penal Code, cooperates in the execution of the offensive by previous or simultaneous act. Article 18 Revised Penal Code. There must be a community of unlawful purpose between the principal and accomplice, and assistance knowingly and intentionally given. U.S. versus Velco 11 Pil 526. To supply material and moral aid in the consummation of the offense and in as efficacious way. People versus Tamayo 44 Pil 38. In this case, appellant's cooperation is like that of a driver of a car used for abduction, which makes the driver a mere accomplice as held in People versus Batalan 45 Pil 573. Citing the case of U.S. versus Lagmay GR number L15009. It is, however, not established by the evidence that in the meeting held in the house of Samuel Dobble, the malefactors have agreed to kill, if necessary to carry out successfully the plan to rob. What appellants may said to have joined is the criminal design to rob, which makes them accomplices. Their complicity must accordingly be limited to the robbery, not with the killing. Having been left in the banca, they could not have tried to prevent the killing as is required of one seeking relief from liability for assaults committed during the robbery. Article 296 Revised Penal Code. Wherefore, Crescencio Dobble and Antonio Romaquin, guilty beyond reasonable doubt, but only as accomplices for the crime of robbery in band. The penalty imposable upon appellants Crescencio Dobble and Antonio Romaquin as accomplices for the crime of robbery in band is prison mayor minimum, which has a range of 6 years, 1 day to 8 years, as provided in Article 295 of the Revised Penal Code in relation to Article 294, Paragraph 5 of the same code. The commission of the crime was aggravated by nighttime and use of a motorized banca. There being no mitigating circumstances, both appellants should each be sentenced to an indeterminate penalty of from 5 years, 4 months, 21 days of prison correctional to 8 years of prison mayor as maximum, and to indemnify the heirs of each of the accused deceased in the sum of 12,000, not 6,000 as imposed by the trial court. Thank you.